Hello, everybody. Welcome to Gujarati Physicians Convention webinar about estate planning and asset protection strategies for physicians. This event is hosted by Gujarati Physicians Convention, and here with me, Dr. Sumul Raval and Syed Nishat with us. Nishat is a fiduciary financial advisor and partner at the Wall Street Alliance Group. His article and interviews about asset protection, common financial mistakes by the physicians are published in MedPage, Today, Medscape. He is regularly quoted and interviewed in media outlets like Forbes, Kevin MD, US News, Investment News, and Yahoo Finance. We would like to make it more audience interactive, not a long, boring presentation. And I will ask question, and Mr. Nishat will answer. And then you can ask some questions, and as well as chat box again. And I thank Nishat for coming in and helping us out for every physician's need that everybody should have a estate planning. Estate planning rules changes every year, and information can be overwhelming and sometimes hard to understand. When we speak to the attorney, also as a physician, we are high risk of getting sued from creditors. Now, what are the steps for estate planning? How to best protect our asset? I'll request Mr. Nishat to go ahead and start this estate planning question answer session. Thank you, Mr. Nishat.
So on the first question, I will ask at this time, please explain what does it mean when we speak about estate planning? What are the components? At what age physicians should think about estate planning?
Thank you.
I took this question from Dr. Kothari.
Thank you, Dr. Raval and Dr. Kothari, to invite us to this wonderful webinar. We have over 50 people and they keep joining in this webinar. So estate planning is very important for physicians. One of my best clients recently passed away during COVID in Texas. And physician in a high risk. So that's why it's extremely important for physicians to actually get the estate planning done as soon as possible. A lot of times people think that estate planning is very complicated. To simplify it, what I did, I made a simple slides for everyone to understand what estate planning is. So when we talk about estate planning, there are mainly three components in estate planning. Number one is
right. So sure. So one of the benefit of the revocable trust is that if anything happens to both of you, that all the assets that actually goes to a trust basically becomes untouchable for the creditors, for the beneficiaries. So tomorrow the children become older and they get into a lawsuit or they get into a divorce, all the assets are protected. So not only you need to have a will, you need to actually have a trust as well. So just to summarize, you need to have a basic will for estate planning, you need to have a living will, and you need to have a revocable trust as well. These are the three major components we talk about estate planning.
So let me get to this point, Nishat. What are the common mistakes as a physician we make when we create the will and a trust?
Yeah, there are three major mistakes we see when we create a will and trust. Number one, mistakes, we see it all the time, is number one is like I have two children, one is Ayan and one is Noam. If I pass away, in the will, I put their name as the primary beneficiary. That's a mistake what we make, because think logically, Dr. Raval, if I pass away, my children become older, they get married and get into a divorce, all the assets become half. So the best way to give it is not under their name. If anything happens to you, you give it under their trust, under their irrevocable trust. So they need to forcefully create a trust and then distribute the asset. In this way, if a lawsuit happen, all the assets are protected. Divorce happen, all the assets protected under their children's name. Number two, another mistakes we see in the will and trust if we create all this revocable trust, but we don't title it. What I mean by titling, your house should be under the name of the trust. Your retirement account beneficiary should be under the name of the trust. Your brokerage account should be under the name of the trust. If you don't fund it, it still goes through the probate process. So make sure you fund it as well, not just have fancy documents. Make sure you move everything under the name of the trust as well. And lastly, mistakes we see it that when people move from one location to another, like my clients move to Florida a lot, like Dr. Kothari is, from Maryland. Nowadays they're moving. If you created a trust into Maryland or New York, if you move to Florida, make sure you update the provisions of Florida statute into the trust as well, because you created into different states. So make sure that every 5 years or whenever you move, incorporate the statutes of the particular state into the trust as well. So these are the three common mistakes we see all the time when we see the estate planning documents.
Well, that's a good to know. Now, also tell us that many, not many, but some of our Gujarati physicians are also non-US citizens. So do they have to worry about any special provision in estate planning?
Yeah, so a lot of physicians actually come to US and J1 visa. In America, if anything happened to husband, the wife gets everything unlimited. There's no gift tax or whatsoever. But it is only for US citizen. It's not true for non-US citizen. The amount is very limited. So if I'm giving an example, a non-US citizen, my wife doesn't get everything unlimited gift tax free. She's to worry about paying up to a certain amount, some gift tax. So when you do the will and trust for non-US citizen, create a provisions there called QDOT, qualified domestic trust provisions there. All QDOT does is basically says that the transfer properties between husband, wife, citizen, non-US citizen, basically interchange without paying any gift tax. So again, if you're non-US citizen, speak to your CPA if QDOT provision makes sense for you.
All right, so that's good to know. Now, if anyone has a child with a special need, if there is some consideration, when do you do the estate planning?
Yeah, so this is a sensitive subject and a lot of physicians don't pay attention to it. So in US, if you have child with special need, there's some government assistance as well. Like for example, rehab program you go to, some centers you go to, the government programs actually goes away if the child have any assets more than $2,000 under the child's name. Again, if the child has any assets more than the child who has a special need more than $2,000 under his or her name, the government benefit goes away. Now, what are the best way to handle all of it? So you create something called special need trust for that child. The benefit of that any benefits goes to the child after you pass away, or for example, any gift you want to give it, as long as you give it until the special need trust, the government benefit prevails. Also, there's something called SSDI, Social Security Disability Income. If the child is severely have some special need, that amount is about $750 per month. Again, if you don't have the special need trust, the money is under the name of the child, more than $2,000, everything is gone. So again, make sure you have a special need trust and the money goes there. And lastly, ABLE account is also important. Let's say a lot of people ask that, can I just open a 529 account for my child who is a special need? Yes, you can do it. Each state have something called ABLE account, up to $100,000 you can do it. But again, the most important thing, not more than $2,000 of the child with special need.
Very good to know. Now, how often should we update the will and trust document?
Yeah, so one thing to people say that I just, created my will and trust, all done. We ask, okay, when did you do it? Well, I have done it in 2000, or I have done it in 2010. Just to give you an idea that state law provisions, statutes changes every 5 to 10 years. So what we recommend that we should update or revisit the will and trust. It's not a one-time thing. Usually every 10 years, 5 to 10 years, we should always revisit. You know, you have children, you have grandchildren, you had previous trustee, now you want to change the trustee. So we always recommend after 5 years, close to 7 to 10, always make some amendments or new statutes, for example, Secure Act, everything can be incorporated into it.
Very good. So the next question I'm going to ask you is extremely common that most people ask is how much is cost for the basic will and a trust?
Yeah, so estate planning is not that expensive. A lot of physicians say, hey, I don't want to go to a lawyer, it's too much money I have to pay. It's a mistake. Just to give you an idea, a basic will and power of attorney health proxy cost about between $600 to $800 if you use an attorney, all right? Now, if you have a revocable trust as well, that is not that expensive either. It costs additional $2,500. So we're talking about altogether between $3,000 to $3,500. A qualified attorney can get the basic will, power of attorney, health proxy, and revocable trust and funding as well. Get it done.
Okay, that's good to know. Now, we will speak about the next topic, which is estate tax. Before that, if I want to see if there's anybody other questions in audience. And then Dr. Kothari will ask all the questions about the estate tax from here onwards.
Nishat, I have one question.
Mhm.
Before we go further, what is the difference between revocable and irrevocable trust? And what will be the cost difference between two?
Yeah, very good question. So far, revocable means that you can change it anytime. Simple, that's what called revoke. You can revoke it anytime. Irrevocable means that once you create it, certain provisions cannot be changed. For example, the beneficiary cannot be changed. The trust provisions cannot be changed a lot of times. So the question could be when to use revocable, when to use irrevocable. The first step is to do revocable trust. If you have not done any basic estate planning and move everything under the house, the brokerage account under the name of the revocable trust. That's the first step. If your net worth is more than $10 million, and we will talk, in a little bit, you have to, in America, call something called state tax, gift tax, or inheritance tax. Those are there, you have to pay. If you want to gift it to the children, you create something called irrevocable trust, because what you want to make sure you don't want to give it under the name of the child. Can we gift it somewhere? That's irrevocable trust comes into play. But the problem with the irrevocable trust, once you gift it, the money is out of your control. So that's called irrevocable, and the money goes estate tax free. So revocable is to avoid probate. While you're alive, we do it. Irrevocable trust only mainly for gifting purpose and asset protection purpose. Cost almost the same. Revocable trust cost about $3,000. Irrevocable trust, again, another $3,000 you have to pay.
Thank you, Nishat. Can I ask a question? What is the estate tax or a death tax, and how does it work?
Okay, all right. Is it better?
Yeah.
Yes.
Okay, so what we're saying that in America, there's something called income tax. There's something called death tax as well. The death tax amount is any amount is more than 24 million right now. So if husband, wife both passed away, the amount is more than $24 million. We have to worry about paying 40% estate tax. So for example, if your net worth is 30 million, I'm giving an example, up to 24 million, nothing to worry about. Anything more than 24 million and 6 million, you have to worry about paying 40% state tax. But there's one problem though. This 24 million is expiring in 2 years. So in 2025, it's coming down to 12 million. Husband, wife, both passed away. Anything more than $12 million, they have to worry about paying 40% state tax. So that's why it is very important. And we're having this webinar because of that. You have 2 years time horizon to do some sort of planning. So if your net worth is substantial, you can gift it right now if you want to.
Is there any strategies that we should worry about in estate planning for the estate tax?
Yeah, it's a very good question. So there are few ideas out there. I'm not going to go all of it, but just to give you an idea, like remember, Dr. Kothari, you asked the question, irrevocable trust and revocable trust. So you can use irrevocable trust and you can actually gift $22 million. I'm just talking about almost 24 million, I would say, because of inflation, out of your state if your net worth is substantial right now before the law change. Every year you can gift about 16, and now the amount went up a little bit, $17,000 to each children. You don't have to worry about filing gift taxes, and this money is out of your state. You can give it to grandchildren as well. Number three, you can buy second to die life insurance policy as well. The life insurance policy kicks in after both husband and wife pass away, and again is very powerful, is very cheap usually. So remember, estate tax is only due if both husband and wife pass away. You can buy second to die life insurance policy. And lastly, you can do a lot of charitable planning. For example, I have my client who does a lot of charitable planning, give money to India. If you have a 501c organization, there's something called zero out charitable planning. We're not going to go too detail about this, but just to give you an idea, if you have, let's say, I'm giving an example, 30 million net worth, up to 24 million, no state taxes, but 6 million, you can give it to charity. You can make your charitable foundation. You can basically, put your children in the payroll of this charitable, and eventually the money belongs to the children. A lot of strategy you can do. So again, this is out of the scope of today's presentation. But again, these are few of the strategies. You should speak to your financial advisor or CPA, which one makes sense for you.
Thank you, Nishat. I started somewhat understanding about your beautiful explanation, and now I may be able to digest slowly more and more. Probably I may have to attend quite few your seminars to understand all these things. But before we go further, can you please explain me somewhat what is SLAT, SLAT, and can you please elaborate it somewhat?
Yeah, it's a good question. So remember, you asked the question, the irrevocable trust. The problem with the irrevocable trust is once you gift it, the money is out of your control. So physician always ask that, hey, what if I gifted my children and they kick me out from the house? Or, and I don't have any control over it. Can I do something? So there's something called SLAT, Spousal Lifetime Access Trust, or it's an irrevocable trust. The beauty of SLAT is you can gift it, but the money is in your control as long as one of the spouse is alive. Just to give you an idea, me and my wife, we both give 12 million each to the SLAT, and I need to use money for myself. The money is out of my state completely. It grows estate tax free. If I need money, my wife can take money out from the SLAT and give it to me. If my wife needs money, I can take the money slash. They cannot directly control it, but as long as one of the spouses is alive, we can just take the money out interchangeably. So in this way, you have better control, more control, and the children only gets the money after both pass away. So you have more control over it. So that's why SLAT is a good way if you want to control your assets.
Very good. There was one question came from the chat box. Can lawyer update existing old trust? And how
Yeah.
much it costs?
Right. So if you have done it about within 5 years, the lawyer can make some small amendments. It costs about few $100s. I cannot exactly pinpoint, but between $250 to $500 small amendments, like, add this trustee, that trustee, those. But remember, every 7 years, a provision change as well. A lot change as well. So at that time, it's better to just rewrite everything. So what happened that the title remains the same. You have to just put the new languages in it. Like, for example, way back, I saw some documents, they're like 5-6 page document only, you create will and trust. But nowadays, the new will and trust, if you include all the provisions, usually it's about 50 pages, right? New provisions are coming. So might as well just pay, few $1,000s and just update the whole thing. That's the way. But small amendment costs few $100s. But if it's more than 7 years, our experience has been to rewrite everything.
Nishat, thank you very much for explaining the estate planning. And me, like OBGYN, and to my age, I have to do the more estate planning. But multi-millionaire Dr. Raval, who practices the high risk practice and with a brain, he has to use, for he needs the asset protection. Do I understand correctly? So there are a lot of doctors who need the asset protection. Can you please throw some more information on it, asset protection, while Dr. Raval asked all the questions related to that?
Yeah, so Doctor, you are in a very good state, Dr. Kothari, Florida. The asset protection is very powerful there. Where Dr. Raval is in New Jersey, New York. It's a creditor-friendly state. So estate planning is important, but asset protection is very important as well, because according to AMA, 60% of physicians over the age of 55 get lawsuit at least once in their life, and this statistic is quite higher for certain profession like OBGYN. No, I'm just gonna piggyback on you say and just focus on Dr. Raval a little bit. But Dr. Raval, I'm just saying in your situation, you're in a high risk profession. What you should do if you own any real estate, make sure it is not under your name. Make sure it is under an LLC. LLC have an in and out asset protection. So it doesn't cost that much, it is fine. Asset protection doesn't have to be expensive because there's some low hanging fruit. Like for example, Dr. Kothari, in Florida, there's something called joint tenants in entirety for bank account. For real estate, as long as you own joint tenants in entirety, is a type of title. If a lawsuit happens, as long as your spouse is alive, the assets are protected. New Jersey, unfortunately, it is only true for real estate. So if you have a real estate, if you have joint tenants in entirety, the assets give you the elements of asset protection that you need. Again, it doesn't cost anything. It's just a title, the state statute. Another good way of doing it, like if you trust your wife or spouse, and husband and wife have good understanding, and the spouse is non-physician, don't have it under your name as a physician, have it under the spouse's name who is non-physician, husband or wife. In this way, if a lawsuit happens, usually malpractice it happens under the name of the doctor, but the spouse is non-physician, no one will go after it. Now, the non-spouse physician can get lawsuit, like say, car accident or a harassment lawsuit. You buy umbrella policy because umbrella policy covers, non-malpractice insurance as well. After you've done all of it, the basic I'm talking about, low-hanging fruit, then your net worth is substantial. You want to do very, very high advanced level. Then you should talk about, if you see my screen, family limited partnership. It gives you the elements of asset protection as well. 401k cash balance plan have unlimited asset protection. You can create asset protection trusts like Nevada, Delaware, Alaska that give you huge asset protection. And obviously, if you have irrevocable trust, you gifted, all the assets are protected. But we would like to see your net worth more than $10 million in order to do anything more than the basic, asset protection stuff we spoke about, like, the Nevada or SLAT or asset protection trust. So first step is do the basic stuff. After you are done with it, talk about advanced planning.
I think Sumul is taking care over, or I can ask you one more question. And in a general information point of view, Nishat, you have been so great and so much information you have given out today that I may have to come and approach you to get me well protected, because I do most risky game of Gujarati conventions. So with that things, I may need to protect myself, because 1,500 to 2,000 doctors' life is on the line when I do the convention. So I appreciate your help today, and have Sumul to continue further asking questions. Sumul, are you there?
Yes, I'm here. So, Nishat, is primary house protected everywhere?
No, so it's a misconception people have that the primary house protected everywhere. Just to give an idea, Pennsylvania, I'm giving you a state, primary house is not protected. Only 2 states actually have huge asset protection. They are Texas and Florida. Anything more than that is the protection is there as long as the titling is correct. If you're just an individual name, there's no asset protection there for primary house. So that's why it is very important that the strategies I outlined here, use some of it if you are not in Florida or state or Texas. So do some sort of asset protection strategies available there for the primary house.
So what are some of the strategy for asset protection for physicians?
Yeah. So as I mentioned, Dr. Kothari asked this question that, joint tenants in entirety, then assets under the non-spouse, under the spouse physician who is a non-physician, assets under the name of the LLC, FLP, umbrella policy, SLAT did give you a decent amount of asset protection that you need.
I see. So how much it costs to set up the trust like Nevada or other asset protection trusts?
Yeah, so this is an advanced topic. Nevada Asset Protection Trust. A lot of physicians ask that, listen, I live into the state like Nevada, where the primary houses or stuff are not protected. Can you try me? Can you give me some idea where I can protect my assets? So you can speak to your CPA or financial advisor about Nevada Asset Protection or Alaska or Delaware Asset Protection Trust. Work almost similar way. Once you move the money into those trusts, and after 3 years, the assets are protected. Another advantage is that if you put the money into those trusts, even if a divorce happened for that particular person, after 3 years, usually it have elements of asset protection as well. Again, it is expensive. Only the net worth is substantial. People should worry about it. And it costs about $5,000 to set it up. And there's a yearly maintenance fee as well, about $1,200. So again, this should be a resort where you're exhausted other stuff and your net worth at least 10 to $20 million, you want to protect it, then you can think about Nevada, Alaska, or Delaware, those trusts.
Right. So that's a lot of information you gave us in last 30 minutes, Nishat. I want to really thank you. I want to see if there's any questions we have in audience before we conclude our last question that I have. If not, I'm gonna ask.
Let me ask a couple of
that
yeah, there are a couple of questions. In Florida, my understanding is primary residence is protected from creditor. Is thus advisable to place your primary house into a revocable trust? So yeah, the primary house in Florida is protected, but remember the probate we spoke about in Florida, it is there in Florida as well. But revocable trust, if you put it, as long as the provisions are there, the assets are protected also. So that's fine. Couple of more questions. How frequently an irrevocable trust document needs to be reviewed and updated? Irrevocable after every 5 years. All right. You should double check. Ajay Parekh asked, also retirement accounts are protected from creditor in Florida, from my understanding, so it is advisable to place your IRA, other retirement account, either revocable, irrevocable trust. So retirement accounts are protected up to a certain amount, about 1.2 million, 401k defined benefit, unlimited asset protection. But remember, you're just putting the beneficiary of the retirement account as the trust, not the ownership. So yeah, you should do it. Primary beneficiary should be the spouse. Secondary beneficiary should be the trust. Say, can we have all the slides to our email? Yes, all the recording will be sent to your email. In order to pass your asset to your spouse, do you still need a will? People ask the question. Yeah, so you need to have a will still, because not everything can be the trust. For example, the jewelry, the car, they cannot be under the name of the trust. You need to have a will as well. If you have a trust, the will simplifies everything. All it says that whatever is not in my will goes to the trust. So you need to have a will as well. Make sure those that are not captured into the trust are captured in the will. You need to do that as well. 3 more questions. What assets under SLAT subject to divorce dispute? So remember, SLAT is irrevocable trust. Anything you put into the trust, irrevocable trust, give you asset protection that you need. So everything should be asset protected by the statutes of the SLAT. What are your thoughts on life estate deeds with power for real estate property? What are your thoughts on life on estate deeds? Yeah, so basically, I think the question is that the real estate properties should be under the name of a revocable, irrevocable, or SLAT. You should title it as well, not under your name. And let me see, any other question? Does your cost estimate include service of an attorney? Yes, it include the $3,500, the revocable trust, will and trust. All I explained, it includes, attorney is the one who's doing everything. I'm the financial advisor. So you just pay the attorney directly and they just take care of that from our side. Elaborate a second to die life insurance policy just to answer. Right now, if you pass away, there will not be any death benefit. Wife also passed away, there will be death benefit. So it's called two people die, only then the life insurance kicks in. So that's called second to die life insurance policy. So these are all the questions I see in the screen.
Well, that's a lot of information in a short duration. I'm sure people have a lot more questions, Nishat. So thank you again for everyone to join on Sunday morning for this very interesting, informative webinar. This video will be available online and will be emailed to you and everyone. We will continue this informative webinar in a future, in a short duration. So whoever did not get chance to log in today will have more opportunities in the future. I want to have a final word from Dr. Ajeet Bhai.
Thank you very much to Nishat and coming and giving us very much information, as well as to all the audience for participation and supporting this kind of the self-motivational estate planning and asset protection seminars. Thank you very much to his team as well as to Sumul for coming and giving me this opportunity. Thank you.
Thank you very much. The recording will be available. I appreciate it. Thank you, Dr. Kothari.
Have a
Dr.
good
Raval.
Sunday.
Have a good day, Sunday. Bye-bye.